Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Justice Quince is not able to attend the oral argument today, but will be participating in the cases. The first case for the day is Hurst versus State of Florida.
May it please the Court, William McLean representing Timothy Hurst. This is a resentencing appeal, and there are two areas of concerns I'd like to address this morning. One being the proportionality of the death sentence in this case, and the second one being the manner in which the trial court handled the mental retardation issue in the case, both procedurally and on the merits. I think the proportionality case would be dispositive, and I'll start with that issue first. This is not the most aggravated or least mitigated of cases, as is required to get past a proportionality argument. There was two aggravators in the case during the commission of a robbery and heinous, atrocious, and cruel, which we are not contesting. There was significant mitigation. Mitigation came from, the mental retardation evidence was presented before the jury, and he had three experts who testified for the defense. Dr. Kropp, who did a neuropsych examination as well as a mental intelligence testing using the WAIS-4 exam. He came out with a 69 IQ on that exam. Dr. Kropp also used the adult behavior assessment system and did an adaptive behavior evaluation and concluded that he met all the criteria for mental retardation, and that was his opinion.
We recently, over here, now I feel like a free agent all the way over. We recently decided the case of Allen versus State. It was released back in July of this year. And in that particular case, the victim was held down and chemicals were poured down her mouth, and then she was gagged, and the two it was a two aggravator case. One of them including HAC, and there was testimony or evidence of substantial organic brain damage and substantial mental issues. How does this case differ from Allen versus State? We've held Allen to be proportional.
It differs in the sense that the aggravation in this case has some. Again, the findings regarding the mental retardation question and the impulse control issues and those kinds of variables. Again, I don't remember the details of the mitigation in Allen, other than those two comments. But we have Mr. Hurst. We have no significant criminal history at all. He was 19 years old, but we have testimony that his mental age was essentially that of a 13-year-old.
Well, the IQs have varied. I mean, we have an IQ of 70, we have an IQ of 76, we have an IQ of 78. It's only WAIS-4 that came out with 69. So he's right there.
The WAIS-4, and again, I would refer to the court to Dr. Taub's testimony, who testified extensively about the difference between the WAIS-3 exam and the WAIS-4 exam. The WAIS-4 exam was more than an evolutionary development in the WAIS testing system. It was more than that. The WAIS-3 was the continuing evolution based upon research that began in 1939 on brain development. But the WAIS-4 has incorporated the more recent research into the system. It has much more subtests. It's a more sensitive test to determine both the high end and low end of the intelligence scale, and is just a substantially better test. He also indicated that what they discovered with the waist 3 was that over a period of time, the scores tended to increase on the waist 3. So Mr. Hurst was tested on the waist 3 13, 14 years ago, but that exam had been in place since much earlier than that. So there had been a number of years where there had been he reevaluated those waist 3 scores in light of the new research and the waist 4, and it did a rescoring of that, which came out consistent with the new, most recent waist 4 exam. That was in Dr. Taub's testimony, corroborating what Dr. Kropp found in his examination. Also, I would note that those two prior scores, the 76 and the 78, were from, well, I'm jumping around a little bit, but this case started out before Atkins. In post-conviction, Atkins had come out, and so there was a mental retardation evaluation done there. That was where we got the 76 and the 78 scores, and they determined that he was not mentally retarded in the post-conviction hearing. That issue was not raised on appeal, most likely given the 70 scoring. Subsequent, and that was back in, he was tested, the crime happened in 1998. He was tested in about 2003 on those prior tests. Now, what happened in the interim is, of course, the waist 4 came out, and in developing mitigation on the retrial of this case, this court reversed the case because ineffective assistance of defense counsel had not developed mitigation. So in that process, the new testing came out with a 69, and two experts concluding that he met the qualifications for mental retardation. In addition, we have Dr. Wu's testimony, who did a PET scan and corroborated the neuropsych exam of Dr. Kropp that he had significant abnormalities in the brain, both frontal lobe and in lack of activity in the back of the lobe, back portion of the brain, which would have given him very poor impulse control, very poor abilities to regulate aggression, very poor abilities for judgment, and all of those kinds of variables. So that's essentially the expert mitigation we have in the case. And again, the crime here itself, even though it was an HAC finding, the nature of the crime itself is consistent with someone who was mentally retarded. It was a very poorly thought out crime. You know, it was admittedly, it was the heinous, atrocious, and cruel factor was validly found, but the circumstances of how that occurred, we don't know all the details. We do know that there was no indication that a murder was planned during the course of the robbery. There was 2 days before, Mr. Hurst had talked to his friend Lee Smith, who was younger, but people who saw them together said he was no doubt the leader of the two, Hurst being more the follower, that he had planned to do the robbery. And the robbery itself was, I mean, he robbed the place where he worked with someone who knew him, and we don't know exactly what precipitated the actual murder. We know she was bound, she was cut pretty extensively. But what is the first thing that Hurst does when he gets through with it? When he gets through with the robbery, he immediately goes to his friend Lee Smith's house, and no doubt with Lee Smith's help, he hides the money at Lee Smith's house. Lee Smith helps him wash his clothes, and then they proceed to spend the money. This is not a sophisticated crime. There was no indication of an intentional crime going on here.
Tied her up and cut her up with a box cutter.
Yes, Your Honor.
But he worked at the Popeye, didn't he?
He did.
And was there any indication of anything personal going on between your client and the victim in this case?
I'm not aware of
any type of animosity towards her for whatever reason?
No evidence of that.
Because he's 19, but he was about 200 pounds, big guy,
Yeah.
and she's like tiny.
Tiny, yes, that's correct. That's correct. I think it's important.
We also had, did the judge place any emphasis on what occurred afterwards? part of the mental state, abilities of the defendant?
And that's one thing I wanted to point out. That seemed to be the only criteria that the court and the state's expert used to say that his adaptive functioning didn't meet the mental retardation standard. Was, well, he was able to do some cover-up after the crime, he was able to give an alibi to the police, and kind of really, the state's expert actually sort of dismissed the kind of evidence that was used in assessing the adaptive functioning from the friends and family members and from some educators who testified. I mean, we had a whole list of things this man could not do, or this young man at the time. He was always very slow. He was difficulty learning to walk. They wanted to place him in special ed, but the mother refused to allow it because he thought she would be stigmatized. He couldn't dress himself appropriately for the weather, couldn't match his clothes, he couldn't manage money. His father had to do that for him. He couldn't follow directions to go somewhere without calling again to getting more directions, or somebody going with him. He couldn't keep appointments. The only reason he kept his job was his mother woke him up every morning to get him to work. He couldn't use the bus. He just had poor difficulty even knowing how to act in public. He couldn't complete tasks, even simple tasks, without someone monitoring to be sure he completed them. He couldn't do basic math. He couldn't even prepare a meal for himself, even following directions on the box. I think his sister may have testified that if you were right there with him, he could perhaps continue to follow measurements to some degree. He couldn't wash his own clothes. He wouldn't even take a shower or bathe himself without somebody reminding him that he needed to do it. The school principal said that Hurst, at 18 or 19, acted like he was a 12 or 13-year-old. He should have been in special ed but wasn't, and he frequently skipped classes. He was socially promoted through middle school. He said that he would skip school, and they sort of tolerated it because they knew he couldn't handle sitting in the classroom, so he'd end up in the basketball court shooting baskets. He did have a driver's license, but his mother said his driving was atrocious, and she was scared to ride with him. This is the kind of individual that we have in this case. This was the factors in the adaptive functioning that Dr. Kropp used in his system.
How did he get the driver's license?
Well, I have no idea.
Have to take a test?
I have no idea.
I haven't done this such a long time.
The state's expert in the case, all of the information from the family and the educators, he dismissed that as just being, those inabilities were just anecdotal. And when he questioned, says, well, don't you put this kind of information into this ABS system to prove this? Well, yeah, you do, says, but these were like family members trying to recall things that happened 14 years ago. Well, Mr. Hurst has been incarcerated for 12 or 13 years. And what parent and what sibling who hasn't lived with someone for 19 years that has these kind of disabilities are not going to forget what it was like. They're not going to forget that. But that was what he referred to. And this court's already addressed the question of whether the lag time and the adaptive behavior information can be used, and that was in the Hodges decision. The only thing Dr. McLaren, the state's expert, referred to was, well, he gave a statement and a summary of what he did, a pretty concise statement. But the detective's testimony in that case says, well, the way this recorded statement was made, it was after we had interrogated him for 2 or 3 hours, and then we just put the tape on and summarized. So he'd already had that, experience of going through the testimony. So it was just a summary of the statement after the long interrogation.
He was working at Popeyes, right?
He was.
What was he doing there?
He was, the only thing I heard saying that morning, he was supposed to come in and help with some of the prepping of the food and he would be under supervision at that time.
How long had he worked there?
I don't recall exactly how long he had been there.
Are there other employment history that he had?
No other employment history I'm aware of. And this, like I said, The expert said he was capable of doing simple, repetitive tasks if he was under supervision. And, this is the type of person that we're dealing with in this case. Given that that what the victim in this case experienced with the knife wounds was heinous, atrocious, and cruel. But on the other hand, we're also looking at an individual who no doubt got himself into the middle of a robbery, and we don't know whether those multiple wounds were indicative of animosity toward the victim. We don't know if it was indicative of just he got into a panic mode maybe during the course of the robbery itself. We don't have any evidence to know that, but
Well, I mean,
there's
I
other
thought that there was evidence that the box cutter cut through some of the tape to make some of the injuries, which
Yes.
would indicate that the victim had already been taped up and secured. So I don't understand the panicking because something that the victim did. I mean, it seems to me is that it's almost conclusive evidence that the victim was totally subdued when the mutilation occurred.
I don't know that it was panicking as a result of anything the victim did at the time, but we're also dealing with someone with these kinds of mental difficulties and intellectual, impulse control, aggression control, and all sorts of things. It may have just, again, we have to speculate because we don't know, but I mean, it's not inconsistent with someone in that nature who got himself in a situation and was panicked just by the situation in and of itself and may have reacted in such a way to cause these multiple wounds. I know we see multiple wound cases where there is mental problems and emotional states at the time of the killing often results in some pretty heinous acts that occur.
But you're not saying this is one of these robbery gone bad cases?
I'm not saying it's a robbery gone bad in kind of the classical sense in which we talk
Not
about
even
that.
remotely. So your basic argument is on this is that it's not proportionate because of significant mental disability?
Yes. That's the proportionality argument.
And how, he was 19, how old was he?
He was 19 at the time.
And what was the testimony about what his mental age was? Was there anything?
In fact, the trial court's findings on this mitigation in the order said he had a mental age of 12 to 13.
That's what the trial court found that?
The
or
trial
that was-
court found age as a mitigator and specifically noted his slow intellect, his immaturity, and his limited ability to care for himself as a basis for giving weight to the statutory mitigator of age. Also found no criminal history at all.
So we have, it's a 7-5 jury
It's a 7-5 jury
recommendation.
rec.
That doesn't figure in at all, though, in our proportionality analysis, does it? That is what the jury recommendation is?
Well, I think it should consider it personally, but I mean, this court, I think, has always looked to the closeness of the vote in evaluating a lot of the issues surrounding the death penalty.
And of course, that goes to your issue of the constitutionality of the statute, where there was no prior violent felony aggravator.
There was no prior violent felony aggravator. There was no prior criminal history, period. I also neglected to mention that Dr. Wu's, just as a side, going back a little bit, Dr. Wu's examination, he said the brain scan he thought was consistent with what he'd seen with people with fetal alcohol syndrome, and that's consistent with the mother's testimony that she drank heavily throughout the pregnancy. The other issue I want to touch on.
You're deep in your rebuttal time.
I'm sorry. I just want to bring to the court the procedural way in which the retardation issue was handled. The defense counsel asked for a new retardation hearing based upon the new evidence he had available, and the judge denied that and said, I'll allow you to present the evidence during the penalty phase, and if I see anything that makes me change my mind from what I ruled in the post-conviction case years earlier, I'll deal with it then. So he did not get a new penalty phase, which I think is completely contrary to what this court did in Hall versus State when they allowed the state to relitigate mental retardation when it came up subsequently. Thank you.
Steve White, representing the state of Florida, Appalachia. Mr. Hurst had 2 mental retardation hearings, full hearings. He had one in the post-conviction proceedings, and he had one here. Basically, what the trial court did is, the trial court said, no, I'm not going to let you argue to the jury that mental retardation is an absolute bar to the death penalty. But the trial court then took all the evidence that defense counsel introduced at the penalty, this new penalty phase, and reached a conclusion that the defense failed to prove adaptive functioning, the deficit in adaptive functioning. The trial court, in her order, in her sentencing order, discussed the test scores and then specifically accredited Dr. McLaren's opinion that the defendant did not meet the adaptive functioning prong of mental retardation in Florida.
Well, as I understand the argument, it's not that the mental retardation bars the death penalty in this case, but that is overwhelming and significant evidence as to mitigation. And certainly, I mean, the state's not of the view that simply because you're not found mentally retarded, that excludes all that evidence for mitigation, are you?
Oh, absolutely not, Your Honor.
Okay, so I mean, that's how he's arguing, as I understand it, not that as you seem to be saying, is, you know, you're arguing that he's not mentally, well, I mean, so what? That's a label, but all the other information is properly before the court, and I think you ought to address that with regard to proportionality.
Absolutely, Your Honor. And the two do overlap. The facts underlying both of those findings do overlap a lot. So let's look at this mentally retarded person who, supposedly mentally retarded person, who can't plan anything, who can't remember things, who's just subject to impulses, et cetera. Well, this supposed organically brain damaged person, to what degree we can debate, and of course the facts belie any significant organic brain damage, although the trial court did find that there was some. But to what degree? And how does it affect proportionality in this case and the finding of mental retardation? Well, we know he had a job. We know that he knew that he was going to be alone with this very petite victim, 4 feet 8.5 inches, 86-pound victim. He's 280 pounds to 300 pounds, 6 feet. He knew he was going to be alone at the Popeyes with her and have access to her without anybody else there at 8 o'clock, roughly 8 o'clock in the morning. He planned the robbery. He told Lee Smith 2 or 3 days before the robbery, I'm going to rob the Popeyes. He arrives at the Popeyes, has access to the victim alone at the Popeyes, knows enough to get electrical tape and bind and gag her, knows enough to basically torture. He somehow got the combination to that safe. He didn't have access to the combination of the safe. Only managers and assistant managers did. This supposedly mentally retarded person, it sounds like he's adapting quite a bit to what he needs to do to get the money out of the safe. That's adaptation, if one ever sees adaptation. He disables the victim. He gets access to the safe. He attempts to clean up the crime scene. He's not thorough about it. Dr. Birkeland testified that he saw water on the floor with blood on the floor, but there's still blood spatter on the wall from when he was torturing her, cutting every side of her head, left, right, front, to the bone, through the lip and the eyelid. As Your Honor indicated, as Justice Lewis, you indicated, some of the cuts were to the tape that gagged her. So he already had her gagged, and he's still torturing her with the box cutter. After the robbery murder, he goes to Lee Smith. He knows enough. He's adapting. He knows enough to get Lee Smith to throw the shoes away and to hide the money. He doesn't go home with the money and with the shoes. Lee Smith sees some blood on his trousers, and the defendant knows enough, adapts to tell Lee Smith, wash these pants for me. The defendant knows enough right after the robbery to go to the Walmart to get another pair of shoes, his size 14 shoes. The defendant knows enough to go to the jewelry store to buy some, I think it was rings, with some of the stolen money. He knows where the money is. They go back to the Lee Smith to get some money to go buy the rings at the pawn shop. And we have the defendant's statement to the police, which the trial court relied on heavily. And I attached it as an appendix to the brief, where he goes into great detail, except for when it's going to incriminate him. He knows enough to adapt to not say that I arrived at the Popeyes. He says, no, my car broke down. And what do we have in his statement? Well, this 2 or 3 hour supposedly rehearsed statement, this mentally retarded person who can't remember things, he remembers times, directions, places, details about what's across the street from what, all in his statement that was recorded and played for the jury, and on which the trial court heavily relied. His statement is objective evidence of his, independent of any other witness, objective evidence of what his mental capacity was. So Dr. McLaren's conclusion that the defendant does not meet the adaptive functioning prong of Florida's definition of mental retardation is supported in the record, abundantly supported in the record by many, many facts. Against that, we have some family members who say, for example, I had to wash his clothes or something, but I also washed his brother's clothes too. I mean, it sounds like to me that, well, maybe perhaps Mr. Hurst didn't want, and the brothers didn't want to wash their clothes, and we don't know whether he was in fact capable of washing his own clothes. Given what we have in the other record here, he certainly was capable of a lot of things, including planning this murder and executing this murder, getting the combination to the safe, getting the money from the safe, hiding the money, disposing of clothes, disposing of other evidence. So when Mr. Hurst wants to adapt, he can adapt. In this particular case, under the facts of this murder, he was in fact adapting. In fact, the trial court rejected the mental mitigation because of a lot of the facts that I've been discussing.
Let me ask you this question.
Yes, Your Honor.
I take it that your position on retardation is that the IQs shouldn't change. If it's a 70, it should be a 70. It's not something that you can learn to do better in. Am I correct?
Well, there is some evidence that if you take the tests sequentially close after one examination close after the other, there can be some sort of a learning effect.
But once retarded, always retarded. That will be your position.
Yeah, that's and according to the Florida statute, Your Honor, as well. You know, you have to mental retardation lasts through life. And by the way, we do have some.
But it doesn't change. You don't get better.
Correct. Pre-18 as well as post-18.
So let me ask you this: just the way we do it now in Florida is the person gets sentenced to death, and then there's this appellate process, and then you have a death warrant. And the determination as to whether the person is not retarded to be executed is determined at the end. They're proposing that we do this in the front end. Why don't we just have a hearing to begin with? If once retarded, always retarded, why don't we have a hearing to begin with before we even do the trial to see if a person is retarded or not? And if he or she is, then we know you can't impose a death sentence. Why don't we just do that in the front end and get all that done?
In fact, I think the Rule 3203 does provide for that. I believe it's 90 days, outside of 90 days before the trial.
Right. So why don't we just make that determination ahead of time and determine that, okay, this person is retarded, he cannot be executed.
In this particular case, though, Your Honor, in 2004, the trial court assessed the Atkins hearing evidence. There was an Atkins hearing back in 2004 and found that he was not retarded and cited to the adaptation, functional adaptation prong of the definition, as well as the test scores of 76 and 78 at the time. Now, again, adaptive functioning is what the state's relying on. That's what the trial court relied on. In terms of the test scores, I mean, we can have an academic discussion about whether the 76 and 78 should be the same as the 69 and what the WAIS 4 and the WAIS 3, how they compare. I mean, Dr. McLaren testified the two tests, 3 and 4, were highly intercorrelated. But here, under the facts of this case, the trial court relied on adaptive functioning, and there is competent, substantial evidence to support that finding, both in 2004 and in 2012. He had 2 Atkins hearings, in essence. And I'm sorry, Your Honor.
No, I just, you recited all this evidence about how how he was functioning. But the judge in his sentencing order says that although he doesn't find him mentally retarded, that's not to say he doesn't suffer from significant mental issues. The court accepts the testimony of Dr. Wu that revealed widespread abnormalities in the brain in multiple areas, including the frontal area, which is crucial to judgment and impulse control. He also said the pattern is consistent with fetal alcohol syndrome. The testimony of the defendant's mother is that she was 15 when she bore him and drank to excess every day while pregnant with him, supports the conclusion that he very well may suffer from fetal alcohol syndrome. All of the experts agree that the defendant has limited intellectual capacity. In fact, the state concedes as much, and then the judge finds that it's been established. Now, that doesn't take away from that this was the nature of this crime, but do you take issue with the trial court's findings regarding the mental state of and status of this defendant, that this defendant has true organic mental disabilities?
He has. No, Your Honor. Short answer to your question is no. And
No, you disagree. You disagree with the trial judge?
No, ma'am. I do. I mean, the state accepts what the trial court found. The trial court relied upon the trial court rejected Dr. Kropp and Dr. Tobe and accredited Dr. McLaren regarding adaptive functioning. But the trial court did, as Your Honor quotes from the order, which I have in front of me also, did rely upon Dr. Wu. The question is, what were the implications of that in terms of this particular case? Well, he has some sort of mental, organic brain problem.
That would influence it influences impulse control, and it also influences his, impulsivity and crucial to judgment. So I guess what this goes to, if we agree with the judge's findings that there is not either, he doesn't meet the failure to for adaptive functioning, that the question is this a proportionate sentence? I think that the facts, again, I agree, support that he did this in not just some kind of frenzy. But his age, I guess what concerns me is his age, the fact that the judge finds him to be equivalent to a 12 or 13-year-old in terms of his functioning, and that he has no prior history of criminal activity. The jury was conflicted with a 7-5 recommendation after hearing all of this evidence. Why is this a proportionate sentence in this case?
Right.
Or why is it either way?
I think a couple of things, Your Honor. One is we need to compare how the trial court dealt with Dr. Wu, as Your Honor quoted the order. But the trial court also discussed mental retardation and adaptive functioning. What are the implications of his brain damage for this case? What was he able to do in this case? And the trial court, not only on mental retardation, but in rejecting substantial impairment and extreme emotional disturbance, talked about what the defendant was able to do in terms of the implications of that brain damage. How much should it impact her decision on this particular case?
So you think that what might separate this from other cases where we have not found it proportionate is that this goes to his, it's not that it's not mitigation, but that it doesn't really, as far as what was happening at the time of the crime, it wasn't the dominating factor causing
Absolutely
the crime to
not.
occur. So
What
you
he
think
was
that
able to do, what he objectively established that he was able to do, not just some family member's opinion about another time of
what do you think the
clothes,
closest case is where we have affirmed the death penalty with similar age, mental disability, et cetera?
There are 4 cases I want to mention to the court. I cited and discussed a whole bunch of cases in the brief. May I make one other preliminary point regarding Dr. Wu, though, Your Honor? I mean, the trial court didn't discuss Dr. Wu in any detail, but if you look at his testimony, he indicated that the PET scan is only one thing that they look at. It's in the context of other factors. Now, he did find organic brain damage. The abnormality is true. But he also testified that the behavior resulting from that brain damage varies. And so what's the behavior here that varies? Well, these are all the facts that the state's been discussing.
I want one about the robbery. Did the jury find that separately in the guilt phase? Was there a finding of
Actually,
robbery?
I thought that they did, but they did not.
So we don't have, again, and I realize the majority of the court has not accepted it, we have a 7-5 with no prior violent felony, so we have no knowledge whether the jury found any aggravator unanimously in this case.
That's correct. The state's relying on Florida law that provides that the defendant is death eligible by virtue of the jury instruction telling the jury that you must find an aggravator in order to recommend the death penalty. In terms of a few cases that I wanted to discuss, Your Honor, Sliney's one, that was 7-5, although that, of course, is not dispositive. The aggravators were avoid arrest and during a robbery. Here we have the
How old was Sliney?
It's 1997.
No, how old was he?
He was age 19. He had no significant prior criminal history, like here. And this court emphasized that there was no statutory mental mitigation, like we have here. Now, there was no mental mitigation in Sliney either, but the emphasis in Sliney was there was no statutory mental mitigation. In that case, he beat the victim with a hammer and stuck a scissor in her neck. Here we have, I hope I don't need to chronicle all of the injuries that the defendant inflicted upon the victim. Another case I would mention, Your Honor, is Gerald's. In that case, CCP was struck by the court, and the remaining aggravators were HAC enduring a felony. There, robbery, burglary. Here we have robbery. The mitigators included age and mental condition bipolar manic. In that case, the victim was bound, like this case. That case, 10 to 15 blunt force injuries and 3 stab wounds. Here we have 60 slash and stab wounds to the victim, including the injuries that I've already mentioned. We have a struggle in that case. Here we have, again, the victim bound, and at some point, there's blood on her knees, so at some point, she knelt in her own blood. We don't know whether she was forced to kneel or whether she fell or what have you. But Gerald's is another case the state would rely on. Hoskins is another one. It's a 2007. Of course, our state relies on all the cases it discusses in its brief as well. In that case, HAC like here, and during a felony, there admittedly there was a sexual battery involved, which would come into play. But still, HAC during another felony, here a robbery, there avoid arrest also. But there you had very significant mental mitigation, low mental functioning ability, abnormalities in the brain, poor academic performance, an abusive background, far more serious mitigation than here. And this court upheld the death penalty. And that one, the victim was gagged like here, and he lied to the police like here. One other case that I would mention, I'll supplement with it. I did bring it to opposing counsel's attention yesterday. Jeffries is a 2001 case, and in that case, engaged in the commission of robbery and HAC. And the court found the statutory mitigator of impaired capacity, which we don't have here. We don't have any statutory mental mitigation. There was a history of emotional and mental problems in there, attempted suicide, and drug and alcohol abuse. And there, in Jeffries, the victim was stabbed several times and also stomped, and there were some defensive wounds. Here, of course, we have the length of time that it took to inflict these 60 cuts and slashes on the victim, gagging her, tying her up, and getting the combination to the safe, and making some attempt towards cleaning up afterwards. So those are 4 cases that the state would especially highlight for purposes of this argument, and otherwise the state relies on all the cases that it discusses in its brief. If there are no other questions, the state would ask the court to affirm the judgment and sentence of death.